Have a seat. Make yourself comfortable. All right, so Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to be addressed immediately, especially with judicial bias and the process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crucell?
Well, it's covering all the judicial bias.
Okay, listen to my question. Is it any different than the last motion to stay proceedings you filed?
Judicial bias.
Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
Judicial bias. I just have a mistake straight to me telling you didn't give a shit about what I had to say.
Okay, hold on. Mr. Crucell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers just cheating green telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago.
That's not the way it works. Mr. Crucell, hold on. Okay, that's the last time you're going to interrupt me today without a contempt of court charge. Is that clear? Is that clear?
Prosecution against me this entire time. No one has made her answer that.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept?
You're supposed to be impartial.
I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So it means if you're agreeing with that, definitely means you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Crucell? No, you have to answer my question. Contempt number one, $100. Answer my question. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes or no? Because I can do this all damn day. And when I get tired of this game, then I tell them to put you in custody because it's contempt of court, criminal contempt in my view.
See, that wasn't so hard, was it? Because if a judge agreeing with the prosecutor automatically counts as collusion, then by that logic, every time the judge agrees with you, that's collusion too. Logic's not looking too good for him right now. Oh, and did I mention he's already racked up 2 $100 contempt fines, and we're not even halfway through this circus of a hearing yet? Buckle up.
Now, any argument you make from there, I'm going to deny because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making.
What statement is that?
It was
I thought we were talking about Judge Green's SOS statement.
When you made the statement that you were setting aside my regular trial, saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting that aside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my point and setting it aside than what you were doing.
Mr. Crucell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
Dog and pony show. This court has failed to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt anytime I tried.
I am threatening you with contempt.
My objections on the record. You make my case. So you're
No,
saying-
no, because third contempt. Do not interrupt me. When I said your objections don't mean shit to me is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence and you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a proper legal objection. When I rule in her favor and you say I object and I say, what's your objection? And you just disagree with me, that's not a legal objection. That's why I said your objections mean shit to me because you're not using the word appropriately. Because you don't know what you're doing. That's what I tried to tell you originally the first time you were here. You've never been to law school. You've never tried a case. You don't know the rules of evidence and all the other things that have to be in play to have a trial go forward appropriately and properly. And
If this trial is really supposed to be in his best interest, then when exactly are they bringing out his bowl of edible highlighters? The judge is absolutely right. Pro-Southeast defendants who've never stepped foot in a law school should seriously think twice before representing themselves, especially in front of a jury. The rules of evidence and courtroom procedure aren't just confusing, they're a total minefield. And let's be real, it almost never ends well for them.
not spinning.
My objections based on you not allowing me to do it. And that's when you told me my objections.
Okay. All right. So let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she's never once admitted on the why is on the prosecutor to prove those things. But there's all sorts of irregularities.
All right. Let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking place now shows exactly that there is enough to show. You're supposed you need to keep
Once again, you're not answering the question I asked. You just said you will not participate. And I asked, what do you mean by that?
fair.
I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me getting all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
Statement I'd like to put on the record is that if whatever you would like to do from there, you can, because I'm open until these things. Like I said,
Hold on. Is this statement preceding all these motions you filed? Okay, then let me make my ruling on all of them. I think there's a motion to dismiss for lack of jurisdiction, correct? Okay. Would you like to respond to that one? Because I think that's already been addressed.
We arrested Mr. Recusal while he was in Huron Township, but Beaufort District Court has jurisdiction over offenses that occur within the township, both civil and criminal. This is criminal and civil.
Did you appeal Judge Green's decision on that motion?
I'm prosecuting because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct?
Getting all the.
I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
Yes.
Thank you. Next motion. Motion to...
The judge can't just.
It was a little hard to catch what he said there, but apparently he believes a judge can't just declare jurisdiction when that's literally the judge's job. And here's the kicker. The so-called incident happened in Huron Township, Michigan, which, by legislative definition, falls squarely under this district court's jurisdiction. So yeah, the court absolutely has the authority to hear this case, no matter how much he wants to argue otherwise.
Appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
All she said was that Judge Martin was setting aside and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And anybody have all the recordings and they're submitted to the court. These things were never said to me. And then she comes in here and makes these accusations and saying that the judge said this, the judge said that.
Fine, then I'll say the same. I'll say the same thing to you. Listen to me. Here, on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me. Because the reason she stated, the Township of Huron issued you a citation. This court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay.
I'll say there's
Okay. Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant because that's my job as the gatekeeper after the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge. Not because I don't like Mr. Crusell. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling. That's not a legal objection. So that's two motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside your defaults. All right. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside, defaults that were set aside are reinstated. Is that really what you want today?
Well, listen,
Mr. Crusell, yes or no? You filed a motion asking me to set aside a decision that was made. Do you really want me to set that decision aside? Because that means those civil infractions are then in default and they're done. Is that a yes or no?
And this is where his complete lack of legal understanding really takes center stage. He's objecting to everything, like a toddler hitting every button just to see what happens. He's even trying to overturn rulings that were made in his favor. Here's the irony. A previous judge already set aside some default judgments against him, meaning those judgments were gone. But now he wants to set aside the set-asides, which would actually bring those same judgments back. You can't make this stuff up.
Do you want me to set aside those do you want me to set aside the default set-asides? Do you want me to reinstate those default judgments? Then I'll deny that motion. All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I. All right. The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
Essentially, yeah.
Okay,
Prosecutors.
okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent, motion for judicial notice. What does that, judicial notice of what?
Certain terms that this prosecutor keeps trying to use and apply in this case that are not the lawful terminology being used. Like, okay,
For example.
you use motor vehicle.
Okay. Motor vehicle's pretty much a term of art in our business.
Law differences between how it's being used. Absolutely.
Well, then you can make those arguments. But you can't tell her she can't use that phrase. Yeah, but I'm not the trier of fact. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, you can make that argument. Is that what you're concerned about? Is you're not going to be able to make the argument?
Yes.
Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions.
All of this has to go. Everything that's taking place.
No.
Exactly.
No, that's not the way it works, Mr. Cassell.
That's not how it works. That's not how any of this works.
No, Mr. Cassell. All right, listen, brother, listen. You don't get to tell me what my job is. I've been doing it for 25 years. Listen. Well, then that's why they have appellate courts for the fourth or fifth time. I decide what this jury gets to see today. I decide. That is, by definition, the role of the judge at a jury trial. I get to decide what goes in front of that jury. If you don't like the decisions I make, you appeal those decisions. That's the way it works. What this jury has to decide today is whether or not you violated the township ordinance on that date. Hold on. None of these legal arguments about whether or not I should recuse myself or whether or not you notice me up for constitutional rights, none of that has to go to that jury. And none of it's going to.
That's the other issue of the trial and emergency stop and motion to stop this.
I already ruled on that.
Certain back acknowledge my motions for my next travel. Nothing to do.
Once again, I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. And you can disagree with me that all day long. But we're going to do it, once again, we're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I encourage you to appeal me. All right? I am open-minded enough to think that perhaps my mindset about your whole travel, whole thing, maybe that's all wrong. So a circuit court judge can tell me I'm wrong. But so far, and I've ruled this way a number of times on the traveling issue, nobody's ever appealed me to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
Even that's that way. You just keep. Each judge has done the same thing. They just keep setting it aside and acting like it doesn't even exist, not allowing me to make my case, which is violating my rights to be able to produce my case in my head.
What's your case that traveling doesn't mean operating?
I was having the fact that this court's violated my due process rights in every way, the judicial bias and the fact.
All right, then appeal me. But today we're having a jury trial.
Stating an unlawful jury trial, and I think that waiting statement I need to get on the record.
All right, but hold on a minute. Once again, I want to know what that means. You're not participating.
Not participate in a jury in a trial where there is clear bias in this court against it.
Okay.
Violates my rights to a fair trial. 100%. And you want to keep overlooking. No, I know they make you seem like they're not a big deal, and
No, your rights are a really big deal.
obviously not, because if you can sit there and say that the things that are happening, the things you're saying, and just try to give these excuses, oh, just because I agree on this, you are aligning yourself with the prosecutor on my right to trial, completely setting aside, not allowing me.
Mr. Purcell, no, I'm not. Listen to me. No, it's not. Listen to me. Listen to me. She could step out of the room, and I still think your travel argument is bullshit. Traveling. The right to travel was when you did it by Shanks Manor.
Exactly. When the Constitution was written, there weren't even horseless carriages yet, let alone actual cars. So while it's true the Constitution protects your right to travel, it definitely doesn't guarantee your right to drive. There's a big difference between walking down a dirt road in 1789 and cruising a Ford down the interstate in 2025.
When you're driving a motorized vehicle or traveling in a motorized vehicle, that brings all those ordinances into play. That's my legal ruling. Appeal it. I encourage you to do that. But that whole traveling argument, which, dude, I've been through that argument a whole lot more than you have. Trust me, in the last 25 years, I've had that argument a lot. Traveling as you try to apply it meant you could not be stopped by the government from walking from one venue to another. But when we got motorized, then the rules kicked in.
Rulings from the American jurisprudence sites that literally state that yes, first of all, you're allowed, and including automobiles, as long as one does not interfere with another's rights. And this has been something that's been established to be secure.
Then appeal me. Take that precedent and appeal me.
As well.
Okay, that's your right. I'm not trying to stop you from doing any of that stuff. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today.
Because just because you're determining it based off of what though? That's what I'm saying. All these things are relevant and they are accurate.
They're relevant to you. They're not relevant to me. I've made the decision. I have made the decision. I made that decision months ago and you didn't appeal that.
I mean, the process we're having,
Which is not an appeal.
is a trained, lawyer, but there's bullshit that you can't do that.
Absolutely, I do that.
100%.
No. Listen to me. Listen to me. If I don't hold you to the same standard I hold her to, then I'm treating you differently than her. How is that unbiased and impartial? You've decided to engage yourself in this venue, in this arena. That means you got to know the jury structure.
Seriously, haven't you repeatedly told the court in prior hearings that it has no jurisdiction over you? If you and your crew keep insisting that, and then threaten me with arrest if I don't show up to your court, my response would be the same. I tell you to get lost.
You have to do it as an untrained layperson. You had free access to qualified, competent legal counsel. They're still here. There's one right there behind you. He's still ready to help you. You chose to do this yourself. That means you've got to know the court rules. You've got to know the statutes and the ordinances. You've got to know the rules of evidence. And if I help you through those lapses in your knowledge base, that's not fair to the prosecutor. Then I'm taking sides. And now I'm not going to let her walk all over you and try to trick you because you don't know some of those rules and statutes. But I am absolutely going to require you to know what you're doing because you've chosen to do it. That doesn't show bias. That shows impartiality.
There is no partial anything. I have the.
Once again, Mr. Crucell, that's your opinion. No, it's your interpretation of the facts. So you have to appeal my decisions. And look, dude, the fact that you're not in a jail cell right now shows how impartial I am.
When Officer Price literally pulled up to me my days before any of this even happened and talked to us about the traveling, even told me I was well within my rights, gave me every clarification that I was well within my lawful rights. This was all a retaliatory thing from the beginning. And then even when the chief called me, he even called me trying to arena. I said, what's that arena? And then he goes towards the motor vehicle. And then he tried to get me to not pursue legal matters. And then he gets mad at me. And then the day that I file for my body cam, I'm getting removed from here on a little league.
And stop. Hold on. I don't doubt that it is. But I think we got into this a little bit the first time you were here. And I told you, that's not proper for this venue. If you want to complain about the way the Huron Township Police Department handled this, you can file a civil lawsuit against them if you want to. But what's in front of me is one civil infraction and 2 misdemeanors. That's what's in front of me.
Oh, and every time I force it to make my case, the court keeps setting all my stuff and not allowing me to be heard.
Because I'm going to make decisions based on the facts. That jury hopefully is going to make decisions based on the facts that are presented.
How can there be facts if this court continues to not allow me to get my facts?
Because the facts you want to get into, what facts do you want to get into? The chief had some conversation with you?
It's not even just that. I mean, well, yeah, regardless, I have all of that to cover too. The fact that my defense, based off what I was doing, I didn't have to produce any of that. It just keeps all just thrown aside. Every single, and just not even trying to acknowledge any of it.
So hold on. I don't understand. Hold on. You want to be able to testify to this jury?
No, it's not, I'm not testifying. That's what I'm saying. It's the amount of judicial bias in this.
I don't know what you think judicial bias means, but I can guarantee there isn't any. At least, you haven't proven there is. And honestly, if there were bias, you wouldn't still be up here turning this hearing into a live-action performance of how to eat a box of crayons in court.
I don't feel I have bias.
Okay, well, I don't feel that I would have a fair trial here with everything that's been taking place by the file policy. Why did we?
And I've denied all these things. I've denied all these things.
Well, of course you can deny it. Again, showing again that this.
Once again, Mr. Cruzel, just because I disagree with you doesn't mean I'm biased against you. Maybe I just think you're wrong. Is it possible we could have a difference of opinion?
Tina Green told me that she was just not acknowledging herself because the Secretary of State will make sure that this isn't a big deal. I'm showing.
I'm not going to.
It's no impartial sport here.
I've never brought a Secretary of State, have I?
The fact, this is where this all stems from. These are the things I've been trying to get noticed. This thing talked about this.
What do you want getting noticed that we're not getting noticed?
The fact that this is collusion and judicial bias.
It is not collusion. What? All right, listen. What are you going to do today? Because I'm ready to bring the jury, and I've denied all. Stop! I've denied all your motions. I'm ready to set the trial. Are you not going to be here?
Again, Your Honor, has established nothing is even put in here, right? And it's especially regarding the jurisdiction stuff.
Once again, we're at $300 now. We're going to $400. I'm going to ask you the question again. I'm ready to call the jury. Are you going to leave?
I don't know. There's no way they're going to be here trial here.
That didn't answer my question. I need to know how I'm going to proceed, because we can have the trial if you just sit there. I'll just tell the jury you've decided to represent yourself and you might not say anything today. So that's the way you want to go with the trial.
I do. It's all case against that.
Okay.
Everything is on the record.
Okay. Okay. No, let's on the record as you feel they should be.
I brought the sites that I left the sites at home and bring up the person's jurisdiction.
And hold on. Once again, I want to because you just walked in the room. Once again, I want to let you know there's a very competent, experienced legal attorney here, defense attorney here, that's more than willing to help you with this if you want his help.
Well, the court actually who was supposed to be.
And that ain't going to happen.
Well, anybody showing you were supposed to recuse yourself. It's in the book.
And I don't think I've shown bias. That's what we keep. Once again, you and I disagree. That's okay. That's America. You have to appeal me. You don't just keep to argue. You don't get to argue the same thing over and over and over until I agree with you. That's not going to happen. I know I am not biased towards you. I also know that your ideas of how the law applies in mine are vastly different. But because I'm in the black robe and I'm in charge of this trial today, my ruling stands until a circuit court judge or some higher court tells me I'm wrong. That's just the reality of it.
That's what I'll have to do. Because this court's not going to rule it the way it's supposed to. Not going to stand by your jurisdiction.
Not by your definition, I'm not.
The Secretary of State, Attorney General, and to you. I've never heard anything. I don't even know if you're lawfully allowed to concede it. You can say that again. It's been proven on the record.
No, it doesn't need to be proven on the record. Show me a statute or a court rule in Michigan that says I got to prove that. Statute, Michigan statute, or Michigan court rule that says I've got to do that.
I have it in there. I thought it was in smoking.
So you're such a great legal scholar.
MCL 168.420 and MCL 168.467 mandates that the judge must file with the state, and you provided 1X. That thing is on the record. You're totally
How lengthy?
It's.
Go ahead. Just so you know, you're putting this on the record. You're putting this on the record. I'm not listening. She'll get the record.
Your Honor, Judge Oak, I respectfully assert that this court has failed to motions by the files of the case. Yeah, well, then so she can make it right.
Thank you.
I respectfully assert that this court has failed to address the critical motions I have filed in this case, including a motion to dismiss for lack of jurisdiction, a motion to recuse for bias, and a motion for relief from judgment. These motions have raised significant concerns about the court's jurisdiction, judicial bias, and violations of due process under both the Michigan Constitution and the U.S. Constitution, particularly the 5th and 14th Amendments. I have also submitted affidavits and motions, including an affidavit of truth and an affidavit of rebuttal regarding the traffic stop by Officer Merrill, which is connected to this case on August 21st, 2023. Citation number 24HR-101-430, which this court also ignored. These documents directly challenge the jurisdiction of the state in this court, and failure to address them constitute a violation of due process rights. Additionally, I have filed an affidavit of not consent, a motion for judicial notice, a motion for clarification of accuser, none of which be acknowledged by the court. In Marbury v. Madison 5 U.S. 137, the U.S. Supreme Court clearly established that any law repugnant to the Constitution is void. I believe the action or lack thereof was forth violent fundamental constitutional principles. In Murdoch v. Pennsylvania 319 U.S. 105, the court reaffirmed that no state may impose fees or penalties for exercising a constitutional right. And Thompson v. Smith 155 reinforced that the fundamental right to judge require that any judicial or administrative proceeding be fair, free from bias, and based on factual evidence. I have serious concerns that this court has disregarded this evidence. I have serious concern this court has disregarded these principles, given its method of dismissing my motions and statements made by Your Honor, who has stated on record that we see things the same way, referring to the prosecutor, township, state, and this court. This admission clearly demonstrates judicial bias and lack of impartiality, which undermines the fairness of these proceedings. It is also significant that Judge Tina Green has admitted in court that the Secretary of State is influencing the rulings, stating that the court is required to enforce certain rulings because of the Secretary of State makes them do so. This further demonstrates that this court is not acting as an impartial judicial body, but is enforcing motor vehicle codes on other rulings based on external directives rather than applying the law independently. The Secretary of State is an executive branch agency, and his influence over judicial proceedings is a violation of the separation of powers and the constitutional right to an independent, fair trial. Furthermore, there is clear evidence of collusion between the sport, prosecutor, and Huron Township, including the Huron Township Police Department. I have submitted body cam footage highlighting violations of department policies by several officers, including Officer Merrill, Officer Sinai, Officer Smith, and Chief Everett Loveless. These violations occurred even after Sergeant Price confirmed that my activities were lawful. Yet this court continues to overlook these crucial facts. Officer Merrill's traffic stops of both myself and my wife are connected to the ongoing retaliation against me and my family, which has compounded the bias and misconduct in this case. Additionally, I have requested Your Honor's oath of office through an affidavit of fact, registration statement, demand request pursuant to the Foreign Agent Registration Act of 1938, and anti-bribery statement request, and I have received no response. This lack of response raises further questions about the legitimacy and legal standing of this court. Moreover, Judge Lisa Martin issued an unsigned default order without jurisdiction or court seal, and during court proceedings, she admitted she did not understand the sui juris. These actions reflect further incompetence and violations of due process. I must also address the township's deliberate attempt to mislabel my private automobile as an off-road vehicle under local ordinance to circumvent our constitutional right to travel. This mislabeling is an attempt to subject me to commercial regulations that do not apply to private, non-commercial travel. This ORV ordinance was never intended for private public roads. Under the Prevail Trust Code, or United States 318 U.S. 363, when government entities operate in a commercial capacity, they lose sovereign immunity and are subject to the same legal standards as private corporations. The court's actions, including the misapplication of commercial motor vehicle codes, further demonstrate its commercial interest in misinterpretation of the law. The Supremacy Clause of the U.S. Constitution, Article 6, Paragraph 2, mandates that this court is bound by the Constitution, which is the supreme law of the land. This court, however, continues to proceed without regard for constitutional protections, violating my rights at every stage of these proceedings. To continue under these circumstances would be a violation of my constitutional rights and an abuse of judicial power. I respectfully request that the court issue rulings on the pending motions, including a jurisdictional challenge, they immediately dismiss this case by citing overwhelming evidence of judicial misconduct, bias, and due process violations. So these issues remain ignored. I will seek immediate appellate relief, hold all parties accountable, including Your Honor, Judge Martin, Judge Tina Green, Prosecutor Caitlin Margaret Foley, Officer Miro, Officer Sinai, Officer Smith, Chief Everett Robbins, and the Huron Township Police Department. I further assert that if this court continues to proceed with the presumption that I am engaged in commerce, it must present evidence to substantiate its claim. Without such evidence, this court has no authority to enforce commercial motor vehicle codes or ORV ordinances upon me in any further